Okay, in our second chapter on corrections, we're going to talk about guarding ethically. So this is not a job many people necessarily aspire to. So usually people who seek out work as a corrections officer are doing so because they need a job or they've had an unexpected job change. And this regular salary and job security are very important to them. And a lot of prisons are built in rural areas, and so in those areas, this may be the only decent employment. In 1989, Lombardo completed a study and found that a third of the officers he interviewed at Auburn considered danger and mental tension as the most dissatisfying parts of their job. The danger being the fact that it was pretty unpredictable if a violent event would occur. So there's constantly the possibility that violence might occur. They also frequently experience personal challenges from inmates, and they tend to view anything that interrupts prison routines as suspicious. Often feel as though they lack support from their supervisors, and they often see things like work release and education release as improper benefits. So rules prohibit corruption in the form of gifts, personal privileges, conflicts of interest, and staff are obligated to report corruption or unethical behavior. Officers often tend to look at inmates as people who failed in their obligation as citizens. So we want to start by remembering that incarceration itself is the punishment, and the purpose of incarceration is not to administer additional punishment over and above the deprivation of liberty. So for example, control over visits can be justified as part of prison security, but it shouldn't invalidate other practices. Searching prisoners is justified based on security, but strip searching may be considered humiliating beyond proper measures. So we want to remember that inmates do not forfeit their essential humanity. Now remember, in New Jack, which you should have read in Corrections, Conover notes that he had no training in ethics. So a humane correctional system is nearly impossible because retribution is our main philosophy. And in institutions where inmates' rights are easily violated, it's easy to ignore then these ethical standards. So remember that guards have discretion, and when we use our discretion in any field that we're in, we want to be careful that we don't venture into ethical issues. So Gilbert argues that administrators should allow COs to exercise discretion when there's an absence of policy or where policy is vague. We also know that there's a subculture, right? In any job, there's a subculture. There's a subculture here for the inmates and a subculture for the prison guards as well. This includes obligations that COs owe to each other. For example, helping other officers beat an inmate is generally unethical, but from the officer's point of view would conform to the norm that an officer must always support another officer against inmates. And so in your book, they talk about prison guard code. Always go to the aid of an officer in distress. Don't lug drugs. Don't rat. Never make a fellow officer look bad in front of inmates. Always support an officer in a dispute with an inmate. And always support officer sanctions against inmates. Don't be a white hat. Remember, we talked about that in the prior chapter. Maintain officer solidarity against all outside groups. And finally, show positive concern for your fellow guards. So when is it appropriate to use force in corrections? We want to think about a couple things. Should force be used at all? Was excessive force used? And is the force justified? So guards often face moral dilemmas. There's a clash between their personal ethics and the expectations of them as guards. The more time they spend in this job, the more they absorb the culture. It's going to be the ability to abstain from morally questionable behavior is going to be a little bit harder. So they tend to construct prison as a separate moral world. They focus on the inmate himself, on relationships amongst guards, and on the individual guard who engaged in the violence. So remember, in Conover's book, New Jack, he says in New York it is permissible to lay hands on an inmate for certain things: self-defense, preventing injury, quell a disturbance, enforce compliance with a lawful directive, or to prevent an escape. And then deadly force can be used to prevent an escape and self-defense or to prevent arson. So guard culture at a Texas facility defined good officers as those who are able to perform routine prison actions and break up fights and maintain discipline without having to always cite inmates for disciplinary actions. And this seems to be things that were really essential for promotion. Verbal assaults were commonly used to humiliate inmates and destroy that inmate's standing in the eyes of other prisoners. And that could be name-calling, racial terms, and threats. Kaufman observed that use of force varies from prison to prison according to the level of security. Force cannot be used to carry out routine tasks. And then inmate assault was questioned in terms of its definition. They tried to differentiate between force to restrain an inmate and that beyond what was necessary. Marquardt notes that unofficial coercion is so common it's a norm for officers. It's not applied arbitrarily, but it is very structured and systematic and used to maintain control. And people who use this system in his study were considered good promotion prospects. So Marquardt found that unofficial use of force had become a parallel system for social control, and so it built a culture of secrecy in which officers at higher levels refrained from talking about coercive displays of force with lower-ranking officers. But lower-ranking officers routinely ask questions about when to use force without ever receiving any decent answers. And so this results in a lot of discretion amongst guards. So use of violence is not intended as a symbol of power, but rather reflects the fact that the COs are very vulnerable. Officers were dissatisfied about official punishments and often sought their own form of justice. And so a study was done at Walpole, which is here in Massachusetts, which is now called MCI Cedar Junction. And they experienced considerable pressure to use violent means to handle prisoners and to engage in violence consistent with norms requiring them to support their colleagues. And this was reinforced by a genuine fear for survival. Walpole always had a lot of really dangerous, violent offenders. So then how do you justify using force against inmates? Well, it's a way to control them. You're hoping it deters inmate violence. It's used for self-defense, but self-defense is defined pretty broadly. It's used to uphold a reputation for meeting aggression with aggression. There's few short-term sanctions, and some basically felt it was natural that there was no need to justify it. So Kaufman then says coercion tends to fuel inmates' anger and hatred rather than suppressing their resistance. Coercion requires staff to constantly increase the severity of sanctions in order to be useful, and it fails to resolve that conflict that is inherent between inmates and guards. So there have been some cases that, of course, have gone to court in terms of use of force. In U.S. v. Nix, Supreme Court held that a determined escapee may kidnap a hostage or kill an officer, and this gives them more latitude than law enforcement in using deadly force. In Whitley v. Albers, excessive force is governed by the Eighth Amendment, and the legal standard is whether or not the force is applied in a good faith effort to maintain or restore discipline. In Clark v. Evans, they said there's no duty to use disabling force rather than lethal force to break up a fight amongst prisoners. In Kenny v. Indiana Youth Center, they said you have to look at various factors to determine if unnecessary and wanton pain and suffering was inflicted. This is sort of like when we talk about totality of the circumstances. You're looking at, is the force needed? What type of injuries inflicted? What was the nature of the threat? And what other efforts were taken that were considered less severe? So then corrections also will have policies on use of force. And Walker analyzed 4 states' policies, and all permitted it to prevent an escape, and 2 suggested that failure to use it to prevent an escape could result in disciplinary action. The American Corrections Association says policies need to be geared to the institution. So in a halfway house, they don't pose a threat to public safety. The Federal Bureau of Prison limits deadly force by prohibiting firearms and minimum security, but does permit it to prevent an escape when authorized by the warden or an officer's judgment that it's necessary to prevent loss of life or grievous bodily harm. But it cannot be used against juveniles. It's also common to prohibit warning shots if they may result in injury. And so if you think about it, that's fairly similar to, a question that gets asked a lot in regard to the police and use of force. Why don't we fire a warning shot? Well, we want to remember that bullets go somewhere, and so a warning shot isn't necessarily safe. And so here we see some data about rape in prison. This data is supposed to be collected through PREA, the Prison Rape Elimination Act, which went into effect in 2003. So all forms of sexual violence inflicted on anyone in custody, including someone that's awaiting trial in county jail. So we've got various studies showing different amounts. Philadelphia, 4.7%. New York, 28%. North Carolina, 2.4%. California, 14%. So part of this depends on how you're defining prisoner rape and what the studies are actually measuring. Reducing the inmate population can reduce rape. So we know that in general, right, when a facility is overcrowded, that's going to create more violence and more problems. So obviously the less overcrowded a facility is, we could reduce rape. But we want to remember also that rape is more pervasive than acknowledged by prison authorities. So most wardens or prison authorities will tell you that prison rape is a problem, but not in their facility. Pretty similar to how a lot of college campuses will agree that rape in college is a serious problem, but not in their facility. So the CO's response then is often imposition of minor disciplinary sanctions, and victims often go into protective custody, which, remember, protective custody looks a lot like segregation. So as I mentioned, PRIA went into effect in 2003, and it sets a zero tolerance. So what it does is it essentially treats inmates the way we treat minors. They're unable to consent. So what PRIA should be collecting data on is all sexual contact in prison. And it's supposed to prioritize prevention of rape. It's also supposed to collect data. But many states are actually not in compliance with this. We also have, other issues, of course, that come up when it comes to ethics and guarding people. We know that our society is becoming a lot more aware of how to deal with transgender folks. But how do we deal with them when it comes to prison? So there's two main approaches. One is to place them based on like their physical genitalia, and another is how they identify. And so this really varies based on, state, how this is handled. Transgender prisoners are at higher risk for being sexually abused. And so a lot of times these inmates will be segregated the same way we would segregate somebody for their protection. In Australia, they follow a social-based and a surgery-based approach. Social-based, the social aspects of an identity, how the person self-identifies, and surgery-based has the inmate undergone gender confirmation surgery. So in the U.S., transgender inmates are often held in solitary based on PRIA laws for their protection. There's been, of course, other issues that happen, and this has been an issue in Massachusetts as well, where, are we responsible for providing hormone therapy, surgery, any sort of treatment that the inmate may have been undergoing beforehand or wishes to undergo. So the DOJ said inmates diagnosed with gender dysphoria must be treated the same as any other medical condition. But many states follow a freeze-frame policy. So you can continue any treatment you were undergoing when you were incarcerated, but you can't get any new treatment. And this policy existed until 2011. Now treatment plans have to be regularly renewed. Hormone treatment may be permitted, even if it wasn't in place at the time of arrest. And in Massachusetts, I think this case has yet to be resolved, but the state has been ordered to pay for gender confirmation surgery for an inmate. So 2015 is the first time we could kind of get an accurate estimate of rates of sexual victimization amongst transgender inmates. So about 35% of transgender inmates say that they have had one or more incidents of victimization in the past 12 months. About a quarter said it involved another inmate, and almost 3/4 said it involved non-consensual sex acts. They also reported levels of sexual misconduct by staff, anywhere from 17 to 23%. So let's also think about corruption. This is the intentional violation of organizational norms by public employees for personal gain. During the first 5 years as director of the DOC in Mass, Vose fired 80 to 100 staff as a result of misconduct. This can include anything from petty thefts to misuse of authority to trafficking and embezzlement. And so we see here some examples of corrupt behavior and what types of officials might be involved. What happens then if someone engages in whistleblowing? So you're working in a facility and you're aware of some corruption and you want to blow the whistle on that. So in 1997, 60 Minutes covered some cases of this in California. And they claimed inmates from different ethnic groups had been set up to fight each other in the small exercise yard, and that officers would place bets. If fights got out of control, officers would sometimes shoot at inmates. And so 6 inmates had been shot dead and many other wounded. By the mid-1980s, a female CO reported her fellow officers for sleeping on the night shift. She had asked them not to and told them she felt unsafe. They basically retaliated against her, putting graffiti on the prison walls, making abusive phone calls, and damaging her car. So basically, the primary oversight mechanism then for prisons is the judiciary. So the Prison Litigation Reform Act of 1995 gave state and local government the right to end judicial oversight of their facilities. And in 2006, the Katzenberg Commission drew attention to the lack of oversight. And private prisons, because they are privately run, have even less oversight. Well, what about ethical issues in probation and parole? So we've got about 4 million people on probation, and the workload of these officers has dramatically increased as we use more and more intensive supervision. POs often face this role conflict, where they're part law enforcement, right, where they're checking up on people for compliance, and they're also part social work. So there's this conflict between surveillance and service. Parole is more surveillance than service, and probation is sometimes more report writing to the courts than either surveillance or service. So here we can just see some data about the number of people on probation and parole. And Badinsky proposes 3 models. There's a law enforcement model, a therapeutic model, and a synthetic model. Now, the synthetic model is ideal. It's a blend of the other 2 models. And of course, the law enforcement, the primary role here is public protection, and in the therapeutic, it's rehabilitation and aiding the offender. But in the past decade or so, we've made probation tougher. And so we're stressing enforcement for sanctions for breaches of probation. So probation today has a new law enforcement emphasis. It's common for POs to be proactive in enforcing probation conditions. And legally, they can ask law enforcement for assistance in searching them. So remember that a probationer and a parolee both have waived their 4th Amendment rights for search and seizure. They have a reduced expectation of privacy. In about 2/3 of state, parole officers are armed, and some argue that probation officers should be armed as well. And some argue that they should not because it creates an atmosphere of distrust. The ACA says there should be a demonstrated need for firearms, and once that's been demonstrated, then we should have clear, adequate, ongoing training. So the goal of probation remains matching the probationer with treatment and rehabilitation services in the community, and ideally caseload should be between 30 and 50 cases. But right now, probation officers are challenged because they have to choose between who amongst their clients will get adequate treatment services, especially when you think about how high of a caseload there is. So there's also private probation, and the largest private probation in Alabama is Judicial Correction Services. But they had to, one city had to terminate its contract with them because there had been a lot of issues, and they were charging a supervision fee of $40 a month. As far as parole goes, at the end of 2013, DOJ reports about 900,000 people are on parole, and the reincarceration rate for them is stable at about 9%. Marcy's Law says the interval between successive parole applications following a rejection has been fixed at 3 to 15 years with an average waiting time of 5 years. And parole, as I mentioned, is really more focused on surveillance than treatment. Here we can see, at-risk parole populations that are returned to incarceration. We also have, federal government doesn't have parole anymore. Currently we have life without parole being served by more than 41,000 inmates. Florida, Illinois, that's probably supposed to be, I don't know if that's supposed to be Ohio or Oklahoma. Louisiana, Maine, Pennsylvania, wow, look at these typos, have all abolished parole. So in Granby, Florida, life without parole for a non-capital offense is a violation of the 8th Amendment, cruel and unusual. prohibition, and has struck down life without parole for juveniles for offenses other than murder. There's also tension between treatment and control has been resolved for parole officers, with control being the main focus, so it's become much more of a policing role. Over 80% of parolees are supervised on caseloads that average about 69 parolees, and they're seen face-to-face less than twice a month.